Article 1801. If two or more partners have been entrusted with the management of the partnership without specification of their respective duties, or without a stipulation that one of them shall not act without the consent of all the others, each one may separately execute all acts of administration. But if any of them should oppose the acts of the others, the decision of the majority shall prevail. In case of a tie, the matter shall be decided by the partners owning the controlling interest. 1693a. Article 1802. In case it should have been stipulated that none of the managing partners shall act without the consent of the others, the concurrence of all shall be necessary for the validity of the acts, and the absence or disability of any one of them cannot be alleged, unless there is imminent danger of grave or irreparable injury to the partnership. 1694. Article 1803. When the manner of management has not been agreed upon, the following rules shall be observed. 1. All the partners shall be considered agents, and whatever any one of them may do alone shall bind the partnership, without prejudice to the provisions of Article 1801. 2. None of the partners may, without the consent of the others, make any important alteration in the immovable property of the partnership, even if it may be useful to the partnership. But if the refusal of consent by the other partners is manifestly prejudicial to the interest of the partnership, the court's intervention may be sought. 1695a. Article 1804. Every partner may associate another person with him in his share, but the associate shall not be admitted into the partnership without the consent of all the other partners, even if the partner having an associate should be a manager. 1696. Article 1805. The partnership books shall be kept, subject to any agreement between the partners, at the principal place of business of the partnership, and every partner shall at any reasonable hour have access to and may inspect and copy any of them. N. Article 1806. Partners shall render on demand true and full information of all things affecting the partnership to any partner or the legal representative of any deceased partner or of any partner under legal disability. N. Article 1807. Every partner must account to the partnership for any benefit, and hold as trustee for it any profits derived by him, without the consent of the other partners, from any transaction connected with the formation, conduct, or liquidation of the partnership, or from any use by him of its property. N. Article 1808. The capitalist partners cannot engage for their own account in any operation which is of the kind of business in which the partnership is engaged, unless there is a stipulation to the contrary. Any capitalist partner violating this prohibition shall bring to the common funds any profits accruing to him from his transactions, and shall personally bear all the losses. N. Article 1809. Any partner shall have the right to a formal account as to partnership affairs. 1. If he is wrongfully excluded from the partnership business or possession of its property by his co-partners. 2. If the right exists under the terms of any agreement. 3. As provided by Article 1807. 4. Whenever other circumstances render it just and reasonable. N. Section 2. Property rights of a partner. Article 1810. The property rights of a partner are: 1. His rights in specific partnership property. 2. His interest in the partnership, and 3. His right to participate in the management. N. Article 1811. A partner is co-owner with his partners of specific partnership property. The incidents of this co-ownership are such that: 1. A partner, subject to the provisions of this title and to any agreement between the partners, has an equal right with his partners to possess specific partnership property for partnership purposes. but he has no right to possess such property for any other purpose without the consent of his partners. 2. A partner's right in specific partnership property is not assignable except in connection with the assignment of rights of all the partners in the same property. 3. A partner's right in specific partnership property is not subject to attachment or execution, except on a claim against the partnership. When partnership property is attached for a partnership debt, the partners, or any of them, or the representatives of a deceased partner, cannot claim any right under the homestead or exemption laws. 4. A partner's right in specific partnership property is not subject to legal support under Article 291. N. Article 1812. A partner's interest in the partnership is his share of the profits and surplus. N. Article 1813. A conveyance by a partner of his whole interest in the partnership does not of itself dissolve the partnership, or, as against the other partners in the absence of agreement, entitle the assignee, during the continuance of the partnership, to interfere in the management or administration of the partnership business or affairs, or to require any information or account of partnership transactions, or to inspect the partnership books. But it merely entitles the assignee to receive in accordance with his contract the profits to which the assigning partner would otherwise be entitled. However, in case of fraud in the management of the partnership, the assignee may avail himself of the usual remedies. In case of a dissolution of the partnership, the assignee is entitled to receive his assigner's interest and may require an account from the date only of the last account agreed to by all the partners. N. Article 1814. Without prejudice to the preferred rights of partnership creditors under Article 1827, on due application to a competent court by any judgment creditor of a partner, the court which entered the judgment, or any other court, may charge the interest of the debtor partner with payment of the unsatisfied amount of such judgment debt with interest thereon, and may then or later appoint a receiver of his share of the profits, and of any other money due or to fall due to him in respect of the partnership, and make all other orders, directions, accounts and inquiries which the debtor partner might have made, or which the circumstances of the case may require. The interest charged may be redeemed at any time before foreclosure, or in case of a sale being directed by the court, may be purchased without thereby causing a dissolution. 1. With separate property, by any one or more of the partners, or 2. With partnership property, by any one or more of the partners with the consent of all the partners whose interests are not so charged or sold. Nothing in this title shall be held to deprive a partner of his right, if any, under the exemption laws, as regards his interest in the partnership. N. Section 3. Obligations of the partners with regard to third persons. Article 1815. Every partnership shall operate under a firm name, which may or may not include the name of one or more of the partners. Those who, not being members of the partnership, include their names in the firm name, shall be subject to the liability of a partner. N. Article 1816. All partners, including industrial ones, shall be liable pro rata with all their property and after all the partnership assets have been exhausted, for the contracts which may be entered into in the name and for the account of the partnership, under its signature and by a person authorized to act for the partnership. However, any partner may enter into a separate obligation to perform a partnership contract. N. Article 1817. Any stipulation against the liability laid down in the preceding article shall be void, except as among the partners. N. Article 1818. Every partner is an agent of the partnership for the purpose of its business. and the act of every partner, including the execution in the partnership name of any instrument, for apparently carrying on in the usual way the business of the partnership of which he is a member binds the partnership, unless the partner so acting has in fact no authority to act for the partnership in the particular matter, and the person with whom he is dealing has knowledge of the fact that he has no such authority. An act of a partner which is not apparently for the carrying on of business of the partnership in the usual way does not bind the partnership unless authorized by the other partners, except when authorized by the other partners or unless they have abandoned the business. One or more but less than all the partners have no authority to 1. Assign the partnership property in trust for creditors or on the assignee's promise to pay the debts of the partnership. 2. Dispose of the goodwill of the business. 3. Do any other act which would make it impossible to carry on the ordinary business of a partnership. 4. Confess a judgment. 5. Enter into a compromise concerning a partnership claim or liability. 6. Submit a partnership claim or liability to arbitration. 7. Renounce a claim of the partnership. No act of a partner in contravention of a restriction on authority shall bind the partnership to persons having knowledge of the restriction. N. Article 18-19. Where title to real property is in the partnership name, any partner may convey title to such property by a conveyance executed in the partnership name, but the partnership may recover such property unless the partner's act binds the partnership under the provisions of the first paragraph of Article 18-18, or unless such property has been conveyed by the grantee or a person claiming through such grantee to a holder for value without knowledge that the partner, in making the conveyance, has exceeded his authority. Where title to real property is in the name of the partnership, a conveyance executed by a partner, in his own name, passes the equitable interest of the partnership, provided the act is one within the authority of the partner under the provisions of the first paragraph of Article 18-18. Where title to real property is in the name of one or more but not all the partners, and the record does not disclose the right of the partnership, the partners in whose name the title stands may convey title to such property, but the partnership may recover such property if the partners' act does not bind the partnership under the provisions of the first paragraph of Article 18-18, unless the purchaser or his assignee is a holder for value, without knowledge. Where the title to real property is in the name of one or more or all the partners, or in a third person in trust for the partnership, a conveyance executed by a partner in the partnership name, or in his own name, passes the equitable interest of the partnership, provided the act is one within the authority of the partner under the provisions of the first paragraph of Article 18-18. Where the title to real property is in the name of all the partners, a conveyance executed by all the partners passes all their rights in such property. N. Article 18-20. An admission or representation made by any partner concerning partnership affairs within the scope of his authority in accordance with this title is evidence against the partnership. N. Article 18-21. Notice to any partner of any matter relating to partnership affairs, and the knowledge of the partner acting in the particular matter, acquired while a partner or then present to his mind, and the knowledge of any other partner who reasonably could, and should have communicated it to the acting partner, operate as notice to her knowledge of the partnership, except in the case of fraud on the partnership, committed by her with the consent of that partner. N. Article 18-22. Where, by any wrongful act or omission of any partner acting in the ordinary course of the business of the partnership, or with the authority of his co-partners, loss or injury is caused to any person not being a partner in the partnership, or any penalty is incurred, the partnership is liable therefore to the same extent as the partner so acting or omitting to act. N. Article 1823. The partnership is bound to make good the loss. 1. Where one partner acting within the scope of his apparent authority receives money or property of a third person and misapplies it, and 2. Where the partnership in the course of its business receives money or property of a third person and the money or property so received is misapplied by any partner while it is in the custody of the partnership. N. Article 1824. All partners are liable solidarily with the partnership for everything chargeable to the partnership under Articles 1822 and 1823. N. Article 1825. When a person, by words spoken or written or by conduct, represents himself, or consents to another representing him to anyone, as a partner in an existing partnership or with one or more persons not actual partners, he is liable to any such persons to whom such representation has been made, who has, on the faith of such representation, given credit to the actual or apparent partnership, and if he has made such representation or consented to its being made in a public manner, he is liable to such person, whether the representation has or has not been made or communicated to such person so giving credit by her with the knowledge of the apparent partner making the representation or consenting to its being made. 1. When a partnership liability results, he is liable as though he were an actual member of the partnership. 2. When no partnership liability results, he is liable pro rata with the other persons, if any, so consenting to the contract or representation as to incur liability, otherwise separately. When a person has been thus represented to be a partner in an existing partnership, or with one or more persons not actual partners, he is an agent of the persons consenting to such representation to bind them to the same extent and in the same manner as though he were a partner in fact, with respect to persons who rely upon the representation. When all the members of the existing partnership consent to the representation, a partnership act or obligation results. But in all other cases it is the joint act or obligation of the person acting and the persons consenting to the representation. N. Article 1826. A person admitted as a partner into an existing partnership is liable for all the obligations of the partnership arising before his admission as though he had been a partner when such obligations were incurred, except that this liability shall be satisfied only out of partnership property, unless there is a stipulation to the contrary. N. Article 1827. The creditors of the partnership shall be preferred to those of each partner as regards the partnership property, without prejudice to this right. The private creditors of each partner may ask the attachment and public sale of the share of the latter in the partnership assets. N. Chapter 3. Dissolution and winding up. Article 1828. The dissolution of a partnership is the change in the relation of the partners, caused by any partner ceasing to be associated in the carrying on as distinguished from the winding up of the business. N. Article 1829. On dissolution the partnership is not terminated, but continues until the winding up of partnership affairs is completed. N. Article 1830. Dissolution is caused 1. Without violation of the agreement between the partners. A. By the termination of the definite term or particular undertaking specified in the agreement. B. By the express will of any partner, who must act in good faith, when no definite term or particular is specified. C. By the express will of all the partners who have not assigned their interests or suffered them to be charged for their separate debts, either before or after the termination of any specified term or particular undertaking. B. By the expulsion of any partner from the business bona fide in accordance with such a power conferred by the agreement between the partners. 2. In contravention of the agreement between the partners, where the circumstances do not permit a dissolution under any other provision of this article, by the express will of any partner at any time. 3. By any event which makes it unlawful for the business of the partnership to be carried on, or for the members to carry it on in partnership. 4. When a specific thing which a partner had promised to contribute to the partnership perishes before the delivery, in any case by the loss of the thing. When the partner who contributed it, having reserved the ownership thereof, has only transferred to the partnership the use or enjoyment of the same. But the partnership shall not be dissolved by the loss of the thing when it occurs after the partnership has acquired the ownership thereof. 5. By the death of any partner. 6. By the insolvency of any partner or of the partnership. 7. By the civil interdiction of any partner. 8. By decree of court under the following article, 1700A and 1701A. Article 1831. On application by her for a partner, the court shall decree a dissolution whenever 1. A partner has been declared insane in any judicial proceeding or is shown to be of unsound mind. 2. A partner becomes in any other way incapable of performing his part of the partnership contract. 3. A partner has been guilty of such conduct as tends to affect prejudicially the carrying on of the business. 4. A partner willfully or persistently commits a breach of the partnership agreement, or otherwise so conducts himself in matters relating to the partnership business that it is not reasonably practicable to carry on the business in partnership with him. 5. The business of the partnership can only be carried on at a loss. 6. Other circumstances render a dissolution equitable. On the application of the purchaser of a partner's interest under Article 1813 or 1814. 1. After the termination of the specified term or particular undertaking. 2. At any time if the partnership was a partnership at will when the interest was assigned or when the charging order was issued. N. Article 1832. Except so far as may be necessary to wind up partnership affairs or to complete transactions begun but not then finished. Dissolution terminates all authority of any partner to act for the partnership. 1. With respect to the partners. A. When the dissolution is not by the act, insolvency or death of a partner, or B. When the dissolution is by such act, insolvency or death of a partner. In cases where Article 1833 so requires. 2. With respect to persons not partners, as declared in Article 1834. N. Article 1833, where the dissolution is caused by the act, death or insolvency of a partner. Each partner is liable to his co-partners for his share of any liability created by any partner acting for the partnership as if the partnership had not been dissolved unless 1. The dissolution being by act of any partner. The partner acting for the partnership had knowledge of the dissolution. Or 2. The dissolution being by the death or insolvency of a partner. The partner acting for the partnership had knowledge or notice of the death or insolvency. Article 1834. After dissolution, a partner can bind the partnership, except as provided in the third paragraph of this article. 1. By any act appropriate for winding up partnership affairs or completing transactions unfinished at dissolution. 2. By any transaction which would bind the partnership if dissolution had not taken place, provided the other party to the transaction A. Had extended credit to the partnership prior to dissolution and had no knowledge or notice of the dissolution, or B. Though he had not so extended credit, had nevertheless known of the partnership prior to dissolution, and, having no knowledge or notice of dissolution, the fact of dissolution had not been advertised in a newspaper of general circulation in the place, or in each place if more than one, at which the partnership business was regularly carried on. The liability of a partner under the first paragraph, No. 2, shall be satisfied out of partnership assets alone when such partner had been prior to dissolution 1. Unknown as a partner to the person with whom the contract is made, and 2. So far unknown and inactive in partnership affairs that the business reputation of the partnership could not be said to have been in any degree due to his connection with it. The partnership is in no case bound by any act of a partner after dissolution. 1. Where the partnership is dissolved because it is unlawful to carry on the business, unless the act is appropriate for winding up partnership affairs, or 2. Where the partner has become insolvent, or 3. Where the partner has no authority to wind up partnership affairs, except by a transaction with one who A. Had extended credit to the partnership prior to dissolution and had no knowledge or notice of his want of authority, or B. Had not extended credit to the partnership prior to dissolution, and, having no knowledge or notice of his want of authority, the fact of his want of authority has not been advertised in the manner provided for. Advertising the fact of dissolution in the first paragraph, No. 2, b. Nothing in this article shall affect the liability under Article 1825 of any person who after dissolution represents himself or consents to another representing him as a partner in a partnership engaged in carrying on business. N. Article 1835. The dissolution of the partnership does not of itself discharge the existing liability of any partner. A partner is discharged from any existing liability upon dissolution of the partnership by an agreement to that effect between himself, the partnership creditor, and the person or partnership continuing the business, and such agreement may be inferred from the course of dealing between the creditor having knowledge of the dissolution and the person or partnership continuing the business. The individual property of a deceased partner shall be liable for all obligations of the partnership incurred while he was a partner, but subject to the prior payment of his separate debts. N. Article 1836. Unless otherwise agreed, the partners who have not wrongfully dissolved the partnership or the legal representative of the last surviving partner, not insolvent, has the right to wind up the partnership affairs, provided, however, that any partner, his legal representative or his assignee, upon cause shown, may obtain winding up by the court. N. Article 1837. When dissolution is caused in any way, except in contravention of the partnership agreement, each partner, as against his co-partners and all persons claiming through them in respect of their interests in the partnership, unless otherwise agreed, may have the partnership property applied to discharge its liabilities, and the surplus applied to pay in cash the net amount owing to the respective partners. But if dissolution is caused by expulsion of a partner bona fide under the partnership agreement, and if the expelled partner is discharged from all partnership liabilities, either by payment or agreement under the second paragraph of Article 1835, he shall receive in cash only the net amount due him from the partnership. When dissolution is caused in contravention of the partnership agreement, the rights of the partners shall be as follows. 1. Each partner who has not caused dissolution wrongfully shall have A. All the rights specified in the first paragraph of this article, and B. The right, as against each partner who has caused the dissolution wrongfully, to damages breach of the agreement. 2. The partners who have not caused the dissolution wrongfully, if they all desire to continue the business in the same name either by themselves or jointly with others, may do so during the agreed term for the partnership and for that purpose may possess the partnership property, provided they secure the payment by bond approved by the court, or pay any partner who has caused the dissolution wrongfully the value of his interest in the partnership at the dissolution, less any damages recoverable under the second paragraph, no. 1b of this article, and in like manner indemnify him against all present or future partnership liabilities. 3. A partner who has caused the dissolution wrongfully shall have a. If the business is not continued under the provisions of the second paragraph, no. 2. All the rights of a partner under the first paragraph subject to liability for damages in the second paragraph. Number 1b of this article. B. If the business is continued under the second paragraph, no. 2. Of this article, the right is against his co-partners, and all claiming through them in respect of their interests in the partnership, to have the value of his interest in the partnership, less any damage caused to his co-partners by the dissolution, ascertained and paid to him in cash, or the payment secured by a bond approved by the court, and to be released from all existing liabilities of the partnership. But in ascertaining the value of the partner's interest, the value of the goodwill of the business shall not be considered. N. Article 1838. Where a partnership contract is rescinded on the ground of the fraud or misrepresentation of one of the parties thereto, the party entitled to rescind is, without prejudice to any other right, entitled 1. To a lien on, or right of retention of, the surplus of the partnership property after satisfying the partnership liabilities to third persons for any sum of money paid by him for the purchase of an interest in the partnership and for any capital or advances contributed by him. 2. To stand, after all liabilities to third persons have been satisfied, in the place of the creditors of the partnership for any payments made by him in respect of the partnership liabilities, and 3. To be indemnified by the person guilty of the fraud or making the representation against all debts and liabilities of the partnership. N. Article 1839. In settling accounts between the partners after dissolution, the following rules shall be observed, subject to any agreement to the contrary. 1. The assets of the partnership are a. The partnership property. B. The contributions of the partners necessary for the payment of all the liabilities specified in number 2. 2. The liabilities of the partnership shall rank in order of payment, as follows. A. Those owing to creditors other than partners. B. Those owing to partners other than for capital and profits. C. Those owing to partners in respect of capital. D. Those owing to partners in respect of profits. 3. The assets shall be applied in the order of their declaration in No. 1 of this article to the satisfaction of the liabilities. 4. The partners shall contribute, as provided by Article 1797, the amount necessary to satisfy the liabilities. 5. An assignee for the benefit of creditors or any person appointed by the court shall have the right to enforce the contributions specified in the preceding number. 6. Any partner or his legal representative shall have the right to enforce the contributions specified in number 4, to the extent of the amount which he has paid in excess of his share of the liability. 7. The individual property of a deceased partner shall be liable for the contributions specified in number 4. 8. When partnership property and the individual properties of the partners are in possession of a court for distribution, partnership creditors shall have priority on partnership property and separate creditors on individual property, saving the rights of lien or secured creditors. 9. Where a partner has become insolvent or his estate is insolvent, the claims against his separate property shall rank in the following order. A. Those owing to separate creditors. B. Those owing to partnership creditors. C. Those owing to partners by way of contribution. N. Article 1840. In the following cases, creditors of the dissolved partnership are also creditors of the person or partnership continuing the business. 1. When any new partner is admitted into an existing partnership, or when any partner retires and assigns, or the representative of the deceased partner assigns, his rights in partnership property to two or more of the partners, or to one or more of the partners and one or more third persons. If the business is continued without liquidation of the partnership affairs. 2. When all but one partner retire and assign, or the representative of a deceased partner assigns, their rights in partnership property to the remaining partner, who continues the business without liquidation of partnership affairs, either alone or with others. 3. When any partner retires or dies and the business of the dissolved partnership is continued, as set forth in Nos. 1 and 2 of this article, with the consent of the retired partners or the representative of the deceased partner, but without any assignment of his right in partnership property. 4. When all the partners or their representatives assign their rights in partnership property to one or more third persons, who promise to pay the debts and who continue the business of the dissolved partnership. 5. When any partner wrongfully causes a dissolution and the remaining partners continue the business under the provisions of Article 1837, second paragraph, no. 2. Either alone or with others, and without liquidation of the partnership affairs. 6. When a partner is expelled and the remaining partners continue the business either alone or with others without liquidation of the partnership affairs. The liability of a third person becoming a partner in the partnership continuing the business under this article, to the creditors of the dissolved partnership shall be satisfied out of the partnership property only, unless there is a stipulation to the contrary. When the business of a partnership after dissolution is continued under any condition set forth in this article, the creditors of the dissolved partnership, as against the separate creditors of the retiring or deceased partner or the representative of the deceased partner, have a prior right to any claim of the retired partner or the representative of the deceased partner against the person or partnership continuing the business, on account of the retired or deceased partner's interest in the dissolved partnership or on account of any consideration promised for such interest or for his right in partnership property. Nothing in this article shall be held to modify any right of creditors to set aside any assignment on the ground of fraud. The use by the person or partnership continuing the business of the partnership name, or the name of a deceased partner as part thereof, shall not of itself make the individual property of the deceased partner liable for any debts contracted by such person or partnership. N. Article 1841. When any partner retires or dies, and the business is continued under any of the conditions set forth in the preceding article, or in Article 1837, second paragraph, no. 2. Without any settlement of accounts as between him or his estate and the person or partnership continuing the business, unless otherwise agreed, he or his legal representative as against such person or partnership may have the value of his interest at the date of dissolution ascertained. and shall receive as an ordinary creditor an amount equal to the value of his interest in the dissolved partnership with interest, or at his option or at the option of his legal representative, in lieu of interest. The profits attributable to the use of his right in the property of the dissolved partnership, provided that the creditors of the dissolved partnership as against the separate creditors, or the representative of the retired or deceased partner, shall have priority on any claim arising under this article, as provided Article 1840. Third paragraph, n. Article 1842. The right to an account of his interest shall accrue to any partner, or his legal representative as against the winding up partners or the surviving partners or the person or partnership continuing the business at the date of dissolution, in the absence of any agreement to the contrary. N. Chapter 4. Limited partnership. N. Article 1843. A limited partnership is one formed by two or more persons under the provisions of the following article, having as members one or more general partners and one or more limited partners. The limited partners as such shall not be bound by the obligations of the partnership. Article 1844. Two or more persons desiring to form a limited partnership shall 1. Sign and swear to a certificate, which shall state a. The name of the partnership, adding thereto the word limited. b. The character of the business. c. The location of the principal place of business. d. The name and place of residence of each member, general and limited partners being respectively designated. e. The term for which the partnership is to exist. f. The amount of cash and a description of and the agreed value of the other property contributed by each limited partner. g. The additional contributions, if any, to be made by each limited partner and the times at which or events on the happening of which they shall be made. h. The time, if agreed upon, when the contribution of each limited partner is to be returned. I. The share of the profits or the other compensation by way of income which each limited partner shall receive by reason of his contribution. j. The right, if given, of a limited partner to substitute an assignee as contributor in his place, and the terms and conditions of the substitution. k. The right, if given, of the partners to admit additional limited partners. l. The right, if given, of one or more of the limited partners to priority over other limited partners, as to contributions or as to compensation by way of income, and the nature of such priority. m. The right, if given, for the remaining general partner or partners to continue the business on the death, retirement, civil interdiction, insanity or insolvency of a general partner, and n. The right, if given, of a limited partner to demand and receive property other than cash in return for his contribution. 2. File for record the certificate in the office of the Securities and Exchange Commission. A limited partnership is formed if there has been substantial compliance in good faith with the foregoing requirements. Article 1845. The contributions of a limited partner may be cash or property, but not services. Article 1846. The surname of a limited partner shall not appear in the partnership name unless 1. It is also the surname of a general partner, or 2. Prior to the time when the limited partner became such, the business has been carried on under a name in which his surname appeared. A limited partner whose surname appears in a partnership name contrary to the provisions of the first paragraph is liable as a general partner to partnership creditors who extend credit to the partnership without actual knowledge that he is not a general partner. Article 1847. If the certificate contains a false statement, one who suffers loss by reliance on such statement may hold liable any party to the certificate who knew the statement to be false. 1. At the time he signed the certificate, or 2. Subsequently, but within a sufficient time before the statement was relied upon to enable him to cancel or amend the certificate, or to file a petition for its cancellation or amendment as provided in Article 1865. Article 1848. A limited partner shall not become liable as a general partner unless, in addition to the exercise of his rights and powers as a limited partner, he takes part in the control of the business. Article 1849. After the formation of a limited partnership, additional limited partners may be admitted upon filing an amendment to the original certificate in accordance with the requirements of Article 1865. Article 1850. A general partner shall have all the rights and powers and be subject to all the restrictions and liabilities of a partner in a partnership without limited partners. However, without the written consent or ratification of the specific act by all the limited partners, a general partner or all of the general partners have no authority to 1. Do any act in contravention of the certificate. 2. Do any act which would make it impossible to carry on the ordinary business of the partnership. 3. Confess a judgment against the partnership. 4. Possess partnership property, or assign their rights in specific partnership property for other than a partnership purpose. 5. Admit a person as a general partner. 6. Admit a person as a limited partner, unless the right so to do is given in the certificate. 7. Continue the business with partnership property on the death, retirement, insanity, civil interdiction or insolvency of a general partner, unless the right so to do is given in the certificate. Article 1851. A limited partner shall have the same rights as a general partner to 1. Have the partnership books kept at the principal place of business of the partnership, and at a reasonable hour. 2. Inspect and copy any of them. 2. Have on demand true and full information of all things affecting the partnership, and a formal account of partnership affairs whenever circumstances render it just and reasonable, and 3. Have dissolution and winding up by decree of court. A limited partner shall have the right to receive a share of the profits or other compensation by way of income, and 2. The return of his contribution as provided in Articles 1856 and 1857. Article 1852. Without prejudice to the provisions of Article 1848. A person who has contributed to the capital of a business conducted by a person or partnership erroneously believing that he has become a limited partner in a limited partnership, is not, by reason of his exercise of the rights of a limited partner, a general partner with the person or in the partnership carrying on the business, or bound by the obligations of such person or partnership, provided that on ascertaining the mistake he promptly renounces his interest in the profits of the business or other compensation by way of income. Article 1853. A person may be a general partner and a limited partner in the same partnership at the same time, provided that this fact shall be stated in the certificate provided for in Article 1844. A person who is a general, and also at the same time a limited partner, shall have all the rights and powers and be subject to all the restrictions of a general partner, except that, in respect to his contribution, he shall have the rights against the other members which he would have had if he were not also a general partner. Article 1854. A limited partner also may loan money to and transact other business with the partnership, and, unless he is also a general partner, receive on account of resulting claims against the partnership, with general creditors, a pro rata share of the assets. No limited partner shall, in respect to any such claim, 1. Receive or hold as collateral security any partnership property, or 2. Receive from a general partner or the partnership any payment, conveyance, or release from liability if at the time the assets of the partnership are not sufficient to discharge partnership liabilities to persons not claiming as general or limited partners. The receiving of collateral security, or payment, conveyance, or release in violation of the foregoing provisions is a fraud on the creditors of the partnership. Article 1855. Where there are several limited partners, the members may agree that one or more of the limited partners shall have a priority over other limited partners as to the return of their contributions, as to their compensation by way of income, or as to any other matter. If such an agreement is made, it shall be stated in the certificate, and in the absence of such a statement, all the limited partners shall stand upon equal footing. Article 1856. A limited partner may receive from the partnership the share of the profits or the compensation by way of income stipulated for in the certificate, provided that after such payment is made, whether from property of the partnership or that of a general partner, the partnership assets are in excess of all liabilities of the partnership, except liabilities to limited partners on account of their contributions and to general partners. Article 1857. A limited partner shall not receive from a general partner or out of partnership property any part of his contributions until 1. All liabilities of the partnership, except liabilities to general partners and to limited partners on account of their contributions, have been paid, or there remains property of the partnership sufficient to pay them. 2. The consent of all members is had, unless the return of the contribution may be rightfully demanded under the provisions of the second paragraph, and 3. The certificate is cancelled or so amended as to set forth the withdrawal or reduction, subject to the provisions of the first paragraph. A limited partner may rightfully demand the return of his contribution: 1. On the dissolution of a partnership, or 2. When the date specified in the certificate for its return has arrived, or 3. After he has 6 months' notice in writing to all other members, if no time is specified in the certificate, either for the return of the contribution or for the dissolution of the partnership. In the absence of any statement in the certificate to the contrary or the consent of all members, a limited partner, irrespective of the nature of his contribution, has only the right to demand and receive cash in return for his contribution. A limited partner may have the partnership dissolved and its affairs wound up when 1. He rightfully but unsuccessfully demands the return of his contribution, or 2. The other liabilities of the partnership have not been paid, or the partnership property is insufficient for their payment, as required by the first paragraph, no. 1. And the limited partner would otherwise be entitled to the return of his contribution. Article 1858. A limited partner is liable to the partnership: 1. For the difference between his contribution as actually made and that stated in the certificate as having been made, and 2. For any unpaid contribution which he agreed in the certificate to make in the future at the time and on the conditions stated in the certificate. A limited partner holds as trustee for the partnership: 1. Specific property stated in the certificate as contributed by him, but which was not contributed or which has been wrongfully returned, and 2. Money or other property wrongfully paid or conveyed to him on account of his contribution. The liabilities of a limited partner as set forth in this article can be waived or compromised only by the consent of all members, but a waiver or compromise shall not affect the right of a creditor of a partnership who extended creditor whose claim arose after the filing and before a cancellation or amendment of the certificate to enforce such liabilities. When a contributor has rightfully received the return in whole or in part of the capital of his contribution, he is nevertheless liable to the partnership for any sum, not in excess of such return with interest, necessary to discharge its liabilities to all creditors who extended creditor whose claims arose before such return. Article 1859. A limited partner's interest is assignable. A substituted limited partner is a person admitted to all the rights of a limited partner who has died or has assigned his interest in a partnership. An assignee, who does not become a substituted limited partner, has no right to require any information or account of the partnership transactions or to inspect the partnership books. He is only entitled to receive the share of the profits or other compensation by way of income, or the return of his contribution, to which his assignor would otherwise be entitled. An assignee shall have the right to become a substituted limited partner if all the members consent thereto, or if the assignor, being thereunto empowered by the certificate, gives the assignee that right. An assignee becomes a substituted limited partner when the certificate is appropriately amended in accordance with Article 1865. The substituted limited partner has all the rights and powers, and is subject to all the restrictions and liabilities of his assignor, except those liabilities of which he was ignorant at the time he became a limited partner and which could not be ascertained from the certificate. The substitution of the assignee as a limited partner does not release the assignor from liability to the partnership under Articles 1847 and 1858. Article 1860. The retirement, death, insolvency, insanity or civil interdiction of a general partner dissolves the partnership, unless the business is continued by the remaining general partners. 1. Under a right so to do stated in the certificate, or 2. With the consent of all members. Article 1861. On the death of a limited partner, his executor or administrator shall have all the rights of a limited partner for the purpose of setting his estate, and such power as the deceased had to constitute his assignee a substituted limited partner. The estate of a deceased limited partner shall be liable for all his liabilities as a limited partner. Article 1862. On due application to a court of competent jurisdiction by any creditor of a limited partner, the court may charge the interest of the indebted limited partner with payment of the unsatisfied amount of such claim, and may appoint a receiver, and make all other orders, directions and inquiries which the circumstances of the case may require. The interest may be redeemed with the separate property of any general partner, but may not be redeemed with partnership property. The remedies conferred by the first paragraph shall not be deemed exclusive of others which may exist. Nothing in this chapter shall be held to deprive a limited partner of his statutory exemption. Article 1863. In settling accounts after dissolution, the liabilities of the partnership shall be entitled to payment in the following order. 1. Those to creditors, in the order of priority as provided by law, except those to limited partners on account of their contributions, and to general partners. 2. Those to limited partners in respect to their share of the profits and other compensation by way of income on their contributions. 3. Those to limited partners in respect to the capital of their contributions. 4. Those to general partners other than for capital and profits. 5. Those to general partners in respect to profits. 6. Those to general partners in respect to capital, subject to any statement in the certificate or to subsequent agreement limited partners share in the partnership assets in respect to their claims for capital, and in respect to their claims for profits or for compensation by way of income on their contribution, respectively, in proportion to the respective amounts of such claims. Article 1864. The certificate shall be cancelled when the partnership is dissolved or all limited partners cease to be such. A certificate shall be amended when 1. There is a change in the name of the partnership or in the amount or character of the contribution of any limited partner. 2. A person is substituted as a limited partner. 3. An additional limited partner is admitted. 4. A person is admitted as a general partner. 5. A general partner retires, dies, becomes insolvent or insane, or is sentenced to civil interdiction and the business is continued under Article 1860. 6. There is a change in the character of the business of the partnership. 7. There is a false or erroneous statement in the certificate. 8. There is a change in the time as stated in the certificate for the dissolution of the partnership or for the return of a contribution. 9. A time is fixed for the dissolution of the partnership, or the return of a contribution, no time having been specified in the certificate, or 10. The members desire to make a change in any other statement in the certificate in order that it shall accurately represent the agreement among them. Article 1865. The writing to amend a certificate shall 1. Conform to the requirements of Article 1844 as far as necessary to set forth clearly the change in the certificate which it is desired to make, and 2. Be signed and sworn to by all members, and an amendment substituting a limited partner or adding a limited or general partner shall be signed also by the member to be substituted or added. And when a limited partner is to be substituted, the amendment shall also be signed by the assigning limited partner. The writing to cancel a certificate shall be signed by all members. A person desiring the cancellation or amendment of a certificate, if any person designated in the first and second paragraphs as a person who must execute the writing refuses to do so, may petition the court to order a cancellation or amendment thereof. If the court finds that the petitioner has a right to have the writing executed by a person who refuses to do so, it shall order the Office of the Securities and Exchange Commission, where the certificate is recorded, to record the cancellation or amendment of the certificate, and when the certificate is to be amended, the court shall also cause to be filed for record in said office a certified copy of its decree setting forth the amendment. A certificate is amended or cancelled when there is filed for record in the office of the Securities and Exchange Commission, where the certificate is recorded. 1. A writing in accordance with the provisions of the first or second paragraph, or 2. A certified copy of the order of the court in accordance with the provisions of the fourth paragraph. 3. After the certificate is duly amended in accordance with this article, the amended certified shall thereafter be for all purposes the certificate provided for in this chapter. Article 1866. A contributor, unless he is a general partner, is not a proper party to proceedings by or against a partnership, except where the object is to enforce a limited partner's right against her liability to the partnership. Article 1867. A limited partnership formed under the law prior to the effectivity of this code may become a limited partnership under this chapter by complying with the provisions of Article 1844, provided the certificate sets forth 1. The amount of the original contribution of each limited partner, and the time when the contribution was made, and 2. That the property of the partnership exceeds the amount sufficient to discharge its liabilities to persons not claiming as general or limited partners by an amount greater than the sum of the contributions of its limited partners. A limited partnership formed under the law prior to the effectivity of this code, until or unless it becomes a limited partnership under this chapter, shall continue to be governed by the provisions of the old law. Title X. Agency. Chapter 1. Nature, form and kinds of agency. Article 1868. By the contract of agency a person binds himself to render some service or to do something in representation or on behalf of another, with the consent or authority of the latter. 1709a. Article 1869. Agency may be express or implied from the acts of the principal, from his silence or lack of action, or his failure to repudiate the agency, knowing that another person is acting on his behalf without authority. Agency may be oral, unless the law requires a specific form. 1710a. Article 1870. Acceptance by the agent may also be express or implied from his acts which carry out the agency, or from his silence or inaction according to the circumstances. N. Article 1871. Between persons who are present, the acceptance of the agency may also be implied if the principal delivers his power of attorney to the agent and the latter receives it without any objection. N. Article 1872. Between persons who are absent, the acceptance of the agency cannot be implied from the silence of the agent, except 1. When the principal transmits his power of attorney to the agent, who receives it without any objection. 2. When the principal entrusts to him by letter or telegram a power of attorney with respect to the business in which he is habitually engaged as an agent, and he did not reply to the letter or telegram. N. Article 1873. If a person specially informs another or states by public advertisement that he has given a power of attorney to a third person, the latter thereby becomes a duly authorized agent. In the former case with respect to the person who received the special information, and in the latter case with regard to any person, the power shall continue to be in full force until the notice is rescinded in the same manner in which it was given. N. Article 1874. When a sale of a piece of land or any interest therein is through an agent, the authority of the latter shall be in writing. Otherwise the sale shall be void. N. Article 1875. Agency is presumed to be for a compensation, unless there is proof to the contrary. N. Article 1876. An agency is either general or special. The former comprises all the business of the principal. The latter, one or more specific transactions. 1712. Article 1877. An agency couched in general terms comprises only acts of administration, even if the principal should state that he withholds no power or that the agent may execute such acts as he may consider appropriate, or even though the agency should authorize a general and unlimited management. N. Article 1878. Special powers of attorney are necessary in the following cases. 1. To make such payments as are not usually considered as acts of administration. 2. To effect novations which put an end to obligations already in existence at the time the agency was constituted. 3. To compromise, to submit questions to arbitration, to renounce the right to appeal from a judgment, to waive objections to the venue of an action or to abandon a prescription already acquired. 4. To waive any obligation gratuitously. 5. To enter into any contract by which the ownership of an immovable is transmitted or acquired either gratuitously or for a valuable consideration. 6. To make gifts, except customary ones for charity or those made to employees in the business managed by the agent. 7. To loan or borrow money, unless the latter act be urgent and indispensable for the preservation of the things which are under administration. 8. To lease any real property to another person for more than 1 year. 9. To bind the principal to render some service without compensation. 10. To bind the principal in a contract of partnership. 11. To obligate the principal as a guarantor or surety. 12. To create or convey real rights over a movable property. 13. To accept or repudiate an inheritance. 14. To ratify or recognize obligations contracted before the agency. 15. Any other act of strict dominion. N. Article 1879. A special power to sell excludes the power to mortgage, and a special power to mortgage does not include the power to sell. N. Article 1880. A special power to compromise does not authorize submission to arbitration. 1713a. Article 1881. The agent must act within the scope of his authority. He may do such acts as may be conducive to the accomplishment of the purpose of the agency. 1714a. Article 1882. The limits of the agent's authority shall not be considered exceeded should it have been performed in a manner more advantageous to the principal than that specified by him. 1715. Article 1883. If an agent acts in his own name, the principal has no right of action against the persons with whom the agent has contracted, neither have such persons against the principal. In such case the agent is the one directly bound in favor of the person with whom he has contracted, as if the transaction were his own, except when the contract involves things belonging to the principal. The provisions of this article shall be understood to be without prejudice to the actions between the principal and agent. 1717. Chapter 2. Obligations of the agent. Article 1884. The agent is bound by his acceptance to carry out the agency, and is liable for the damages which, through his non-performance, the principal may suffer. He must also finish the business already begun on the death of the principal, should delay entail any danger. 1718. Article 1885. In case a person declines an agency, he is bound to observe the diligence of a good father of a family in the custody and preservation of the goods forwarded to him by the owner until the latter should appoint an agent or take charge of the goods. N. Article 1886. Should there be a stipulation that the agent shall advance the necessary funds, he shall be bound to do so except when the principal is insolvent. N. Article 1887. In the execution of the agency, the agent shall act in accordance with the instructions of the principal. In default thereof, he shall do all that a good father of a family would do, as required by the nature of the business. 1719. Article 1888. An agent shall not carry out an agency if its execution would manifestly result in loss or damage to the principal. N. Article 1889. The agent shall be liable for damages if, there being a conflict between his interests and those of the principal, he should prefer his own. N. Article 1890. If the agent has been empowered to borrow money, he may himself be the lender at the current rate of interest. If he has been authorized to lend money at interest, he cannot borrow it without the consent of the principal. N. Article 1891. Every agent is bound to render an account of his transactions and to deliver to the principal whatever he may have received by virtue of the agency, even though it may not be owing to the principal. Every stipulation exempting the agent from the obligation to render an account shall be void. 1720a. Article 1892. The agent may appoint a substitute if the principal has not prohibited him from doing so, but he shall be responsible for the acts of the substitute. 1. When he was not given the power to appoint one. 2. When he was given such power, but without designating the person, and the person appointed was notoriously incompetent or insolvent. All acts of the substitute appointed against the prohibition of the principal shall be void. 1721. Article 1893. In the cases mentioned in Nos. 1 and 2 of the preceding article, the principal may furthermore bring an action against the substitute with respect to the obligations which the latter has contracted under the substitution. 1722a. Article 1894. The responsibility of two or more agents, even though they have been appointed simultaneously, is not solidary, if solidarity has not been expressly stipulated. 1723. Article 1895. If solidarity has been agreed upon, each of the agents is responsible for the non-fulfillment of agency, and for the fault or negligence of his fellow agents, except in the latter case when the fellow agents acted beyond the scope of their authority. N. Article 1896. The agent owes interest on the sums he has applied to his own use from the day on which he did so, and on those which he still owes after the extinguishment of the agency. 1724a. Article 1897. The agent who acts as such is not personally liable to the party with whom he contracts, unless he expressly binds himself or exceeds the limits of his authority without giving such party sufficient notice of his powers. 1725. Article 1898. If the agent contracts in the name of the principal, exceeding the scope of his authority, and the principal does not ratify the contract, it shall be void if the party with whom the agent contracted is aware of the limits of the powers granted by the principal. In this case, however, the agent is liable if he undertook to secure the principal's ratification. N. Article 1899. If a duly authorized agent acts in accordance with the orders of the principal, the latter cannot set up the ignorance of the agent as to circumstances whereof he himself was, or ought to have been, aware. N. Article 1900. So far as third persons are concerned, an act is deemed to have been performed within the scope of the agent's authority, if such act is within the terms of the power of attorney, as written, even if the agent has in fact exceeded the limits of his authority according to an understanding between the principal and the agent.